All right, I think we're going to go ahead and get started today. Welcome all. We're excited to bring you today's webinar, Employment Updates, a Year of Challenge and Change. For those of you that have been joining us each week, you know that we have tried to bring weekly webinars on a variety of topics that are important to you. Today, we're looking at topics in employment law that we think are significant and timely. We know this year, 2020, has been challenging and changing in so many ways, and employment law is no exception to that. I'm excited to be on this panel with my partners, Rima Hartman and Stuart Roberts. I have had the pleasure of working with Rima and Stuart my entire legal career, and in my unbiased opinion, they are the best at what they do. All three of us are part of our labor and employment group here at Bressler, and we regularly advise clients and defend lawsuits and arbitration claims. We're going to jump right into the topics for today so that we can have time to adequately cover them. But I did want to let you know that if you have questions along the way, there's no need to wait till the end. If you can put those in the Q&A box, the questions and answers box, we'll try to watch that throughout the presentation and answer them as they come up. If we don't get to your question and you still want to contact us for Rima and for Stuart and I, please feel free to contact us after the presentation with your question and we'll respond. Shoot us an email, give us a call. We're happy to help. So today we're going to focus on three different topics. First, Rima is going to share her insights on the Bostock U.S. Supreme Court case from earlier this year and what employers need to do in response. I'm going to talk about political expression in the workplace, and Stuart will focus on managing your workforce during the pandemic. Before I turn it over to Rima, though, I did want to tell you, we acknowledge that yesterday the Supreme Court did hear arguments on the Affordable Care Act. And as you probably recall, one side is asking the court to strike down the act in its entirety. The other side is claiming the case should not even be there at all. And if so, the act should not be struck down. We don't know what the court is going to do. It will be months, if not next June, before we know, but we'll be watching and we'll let you know as soon as we know the outcome. Rima, we do know what the court has already ruled on this year, and Rima is going to start with that.
Thanks, Matthew. So I want to talk today about the United States Supreme Court case, Bostock versus Clayton County, Georgia, which came out earlier this year, and I expect will have wide-ranging ramifications. We're already seeing that it does. I think the significance of the Bostock case was not missed by anyone. It was a splashy headline, but it may be that the full range of its implications have not yet been fully appreciated. So I want to talk about some of the things that it means for the employer and the workplace. Next slide, please. So as everyone on this call knows, Title VII makes it unlawful for an employer to fail or refuse to hire, to discharge someone, to fail to promote someone or demote someone on the basis of their sex. And the words in the statute are because of the employee's sex. And it's those three words that I think we really need to think about today and that Bostock addresses. And it's in two parts. Out in the world, the ruling is getting a lot of attention for what it said about the word sex and what is sex discrimination. And in the legal community, I think people are taking note of what the ruling said about because of under Title VII. So we're going to talk about both of those things. Next slide, please. So first, let's just be clear that Bostock versus Clayton County decided three separate cases. The first involved a man named Gerald Bostock who was terminated for conduct unbecoming an employee after he joined a gay softball team. The second, Altitude Express versus Zarda, came out of the Second Circuit, and that employee, Donald Zarda, was terminated after he shared with a customer that he was gay. And the third case, RG and GR Funeral Homes versus EEOC, in that case, an employee who had presented as a male for many years was fired after telling her employer that she planned to live as a woman. And when she returned from vacation, she was dressing as a woman, and she was fired in connection with the dress code violation. So those are the factual scenarios that gave rise to the particular claims. But as the majority in the Bostock opinion wrote, Few facts are needed to appreciate the legal question we face. Each of the three cases before us started the same way. An employer fired a longtime employee shortly after the employee revealed that he or she is homosexual or transgender. So it's a very, very simple fact pattern that gives rise to a very important legal ruling. Next slide, please. It was Justice Gorsuch that wrote for the majority in Bostock, and he was joined by 5 other justices, as you see there. It was Gorsuch, Roberts, Ginsburg, Breyer, Sotomayor, and Kagan in the majority, and Alito, Thomas, and Kavanaugh in the minority in the dissent. And we now have Justice Amy Coney Barrett, and I think most people think she would align with the dissenters, but we need to give her a chance to make her own rulings. So we'll see. Next slide, please. So what did the Bostock ruling say? These are 2 of the most quoted lines from the case. It is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. And an employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. And then here's another really interesting quote that's not on the slide. We agree that homosexuality and transgender status are distinct concepts from sex. But discrimination based on homosexuality or transgender status necessarily entails discrimination based on sex. The first cannot happen without the second. And so that I want to highlight what that means. I mean, the court is making clear that it is not adding protected categories to Title VII's list, but rather, in this opinion, it is explaining how those concepts of sexual orientation and gender identity fit within the already existing category of sex discrimination. Bostock and Zarda show employers firing male employees for being attracted to men, which is conduct that they accept in female employees. And in the funeral home case, we see an employer firing a formerly male employee for dressing as a woman, conduct that the employer accepts in female employees. So that's a really important legal distinction that the court made. The next slide, I think, probably is unnecessary. I know we have a very sophisticated audience, but I just wanted to point out the differences between these concepts. Sexual orientation is about the person's attraction or lack of attraction to other persons based on gender. It includes heterosexuality, homosexuality, bisexuality, asexuality. It's a spectrum of categories. Gender identity is about the person's internal, deeply held sense of their own gender. And examples are male, female, non-binary, genderqueer. That again is a spectrum. It's not, 2 categories. And then gender expression is how that person presents outwardly, what signals they give to the outside community by maybe their name, pronouns, clothing, and their gender expression may or may not conform to stereotypes or norms that other people expect in a given culture or historical period. So the next slide shows that we're already seeing new and interesting cases and arguments relying on Bostock. Bostock came out in June, and already new cases, novel applications are cropping up. So in the District of Arizona, the Toomey case involves a transgender male professor who is suing his employer's health plan for gender bias because it will not cover a hysterectomy for him. In Simmons versus Amazon, which is a case pending in the District of New Jersey, a transgender man is suing his employer for pregnancy discrimination. And then in a case that was already pending when Bostock came out, U.S. Pastor Council versus EEOC in the Northern District of Texas, the plaintiffs are arguing, they amended their complaint to argue that under Bostock, sex-neutral rules, like a rule banning all employees from going to gay bars or doing other things that are normally associated with homosexuality, are permissible because you're treating men and women the same. I would hazard a guess that that argument will not prevail based on Bostock. I I think they're misreading the Supreme Court case. So what are the implications of Bostock in your workplace? Next slide, please. There are some that I think are obvious, some may be less obvious. Let's start with the obvious. Don't take any adverse employment action against anyone because they are gay or trans or anywhere on any of the spectrums that we discussed a few moments ago. Make sure that your workplace is free from harassment or bias on that basis. So I think it's a good moment for employers to take a hard look at their workplace and ask, are we ready to welcome LGBTQ people fully? Are our managers ready to respond to the types of issues that may arise? You may need training. That training can be on a continuum. It could be training specifically focused on exclusively the LGBTQ issues that arise. It could be integrated into a broader curriculum, and the training that's needed obviously will differ by audience. But I do think it's an important moment for employers to pause and look at their workplace in a critical way and consider what training opportunities exist. I think clearly defined expectations are especially important for the manager and the colleagues of a person who is transitioning. It presents tricky issues, and I think an employer would do well to support the manager and the colleagues of that person so that they are handling themselves appropriately in the workplace. There also may need to be an update to a company's EEO policy. It needs to state specifically that discrimination and harassment based on a person's actual or perceived LGBTQ status violates policy. This is a new requirement for employers in 26 states. Prior to Bostock, 26 states did not have state laws that prohibited that discrimination. So many employers had that in their policies anyway, as a matter of just doing the right thing. But it's a new legal requirement, and the policies need to be updated if they don't already say that. Also, take a look at your dress code and grooming policies. As I mentioned earlier, the funeral home case that was part of the Bostock opinion turned on a dress code violation. And it seems like a mundane thing, but try to make sure that your policies are gender neutral, less specific than they used to be. I mean, I remember when I started out writing handbooks, people put in their handbooks a dress code for women and a dress code for men, and there were mentions of ties and skirts and earrings and long hair, and we're not doing that anymore. Make your policies gender neutral. They can even be as simple as dress professionally, business casual, and then be careful how you apply the policy. And always leave room for an employee to tell you that a policy's application is presenting difficulties for them. We've seen that in the religious discrimination context. We always leave room in our handbooks for a person to say, that the requirements of a dress code are impinging on someone's religious expression, and we need to do the same thing with regard to gender. What are some other things to consider? The Bostock opinion states, quote, "We do not purport to address bathrooms, locker rooms, or anything else of the kind," which is great, except that employers do not have the luxury of not addressing those things. So consider them. You should consider proactively designating some restrooms as private or unisex. You should also not stop anyone from using the bathroom that matches their gender identity, their internally held belief. If you have forms in your workplace that have check a box, male or female, like your job application, you should revisit that. Create an other box or create other categories besides male or female. Pronoun usage is a big one. Allow people, but do not require them, to state a pronoun preference, either in their email signatures or on their business cards or wherever they would like to do that. I think you should allow it, but again, not require it, because there's that tricky thing. You're not going to be deciding for someone that they're out about their, gender identity or their orientation. So pronoun usage is a big one. In your EEO reporting, I think we're going to see changes there. And another very big issue is, as we saw in the Toomey case out of Arizona, insurance coverage for transitioning employees. There are going to be ADA and FMLA implications, when someone is transitioning. there are arguments on both sides as to whether that's a disability that needs accommodation. And then privacy, again, whether an employee is out is exclusively that person's choice, and information about a person's status, LGBTQ status, can constitute confidential medical information under privacy laws like HIPAA. And that is one of the issues that arose in the Simmons versus Amazon case. The supervisor shared information about the pregnancy with other employees without that employee's permission. So those are some of the implications.
Yeah. Rima, can we go back to the pronoun usage you've got? We've had a lot of questions, and I heard you say that you are allow, but don't require all employees to express what their pronoun usage is. But what about other employees in the workplace? What about other employees who say, I don't want to use what they would consider to be different pronouns for a coworker or even for a direct report? Is there liability for the employer, and what should employers do in those situations?
Right. It's part of a larger theme. Actually, I'm going to discuss it on a later slide, of people's religious liberties. These two trends in the law kind of coming to an inflection point where some people are claiming that their religious liberties in the workplace are infringed if they have to acknowledge other people's gender identity, or have to get with the program essentially on what somebody else wants them to acknowledge as their pronouns. I think there's a very interesting case. I think, Matthew, you're going to talk about it a little bit later in your presentation about Kroger, an employee who didn't want to wear a rainbow, wanted to cover up a rainbow flag that their employer was requiring people to wear, claiming that it was a religious liberty violation. So I would say about the pronoun question, and we have gotten that question a good bit, is that, not using someone's preferred pronouns will probably not, standing alone, constitute discrimination on the basis of sexual orientation or transgender status. But I would not be at all surprised to see that listed among a number of things that someone's claiming constituted a hostile work environment for them on that basis. So I think employers, it is a very dicey thing, and we're going to see how these cases turn out, like the Kroger case. Do you want to just quickly tell people about the Kroger case, just foreshadow your presentation?
Sure. An interesting case out of Arkansas. Kroger, and you'll hear a little bit more about it later, but Kroger changed their uniforms, and the aprons that employees wore all of a sudden had a rainbow image on the uniform. And there were employees who complained, saying that violated their religious liberties. They said that they viewed that as a sign of support for the LGBTQ community. Eventually, a couple of those employees were actually fired when they refused to wear the apron. They wanted to bring their own, or they kept covering up the emblem. And the EEOC said that is religious discrimination and retaliation. And that case is pending in Arkansas right now. And it's going to be very interesting to see how the court rules.
Very. Okay, we want to shift gears a little bit with the next slide and talk about kind of what the lawyers out in the world are talking about with regard to Justice Gorsuch's Bostock opinion. You may have noticed it's causing a little bit of an uproar in terms of its discussion of but-for causation. In our practice, we've already seen Bostock cited in almost every single plaintiff's brief we've received this summer or fall about what is perceived anyway to be a change, or at least a clarification in the causation standard that applies under Title VII. So what did Justice Gorsuch say? He said an employer violates Title VII when it intentionally fires an employee based in part on sex. That's the language that's important. And then he added that a but-for test directs us to change one thing at a time and see if the outcome changes. If it does, we have found a but-for cause. So why the uproar? What's the big deal? Next slide, please. Since 1991, Title VII has set forth two standards for proving causation in discrimination cases, as distinct from retaliation cases. So we'll talk about that in a second. But in discrimination cases, there's but-for causation. And here the question is, as Justice Gorsuch put it, but for the discriminatory motive, would this have happened? Would this challenged employment decision have happened but for the discriminatory motive? The problem is that courts were very inconsistent as to whether that meant that sex had to be the sole cause or the primary cause or something else for the challenged decision. And there were cases all over the place, but certainly I would say most practitioners in this space understood that but-for causation was a heightened standard of causation, as distinct from the other way that you could prove discrimination, which was the mixed motive standard or the motivating factor standard, where the challenged employment decision, though motivated by an impermissible reason like sex, would have also been the same decision would have also been made for a permissible reason. So in those cases where there was a mixed motive, the employer could still be liable, but the remedies are limited. So as I said, Bostock at least clarifies the meaning of but-for causation, even if it doesn't change it. We now know for sure that but-for causation does not require that sex be the one and only cause. It must be a necessary condition for the harm. And if but-for causation is not as heightened a standard as it was once thought to be, then summary judgment is going to be harder to achieve, not only in Title VII discrimination cases, but also in retaliation cases and in cases arising under the ADEA and Section 1981, where there is only one standard, and it's but-for causation. So that's why the uproar. So as we talked about, next slide, please. As we talked about a moment ago, there is this tension between two developing areas of the law. And the slide, we call it a tension, but I actually think that these sets of cases it's more accurate to say they're on a collision course with each other. That you have on the one hand, cases involving LGBTQ equality, like Obergefell, which dealt with marriage equality, and Bostock, which, as we've talked about, dealt with workplace equality. And then on the other hand, you have the Religious Freedom Restoration Act and cases applying that in the workplace, like Burwell versus Hobby Lobby, and the case involving the Little Sisters of the Poor, where the ACA's birth control mandate was said to violate the religious liberties of the employers, and those religious liberties were upheld. The employers won those cases. And I do think that there's just a basic inconsistency developing. Now, Bostock did not ignore that tension, but it also did not resolve it. Here's what Justice Gorsuch wrote about that. The Supreme Court has recognized that the First Amendment can bar the application of employment discrimination laws to claims concerning the employment relationship between a religious institute and its ministers. And that term ministers is interpreted quite broadly. He also said, because the Religious Freedom Restoration Act operates as kind of a super statute, displacing the normal operation of other federal laws, it might supersede Title VII's commands in appropriate cases. And then, super helpfully, they wrote, how these doctrines protecting religious liberty interact with Title VII are questions for future cases. So I think what we're going to see is cases arising, for example, like whether health insurance for trans employees when they're seeking gender-affirming surgery or hormone replacement therapy, or hormone treatment, whether those will have to be covered. So we'll be looking out for that. Next slide, please. I started the presentation by saying that the implications of Bostock will be wide-ranging, and I want to end my presentation by saying these are some of the areas to watch. So outside of the employment context, we expect to see Bostock have a carryover effect in the world of education, where there are issues about bathrooms, locker rooms, pronouns, athletics. In the military, almost simultaneously with the Bostock opinion, there was a denial of insurance. There was an executive order denying insurance coverage for transition care in the military, and the transgender ban being reinstated. Housing access cases involve, equal access to rental properties, assignments in homeless shelters, which are typically now segregated by male, female, barracks. There are healthcare issues, access issues. For example, I know that some OBGYN clinics refuse to see patients who now identify as male, and will that be allowed? So in short, Bostock is a watershed case. It will definitely be resulting in changes in the workplace and in society more generally. And I'm sure that, you know, if we put on another webinar this time next year, I would have much more to report on this front. It's a very, very active area of the law. I hope I didn't go over my allotted time, but please let us know if you have questions. Thanks for your attention.
Great, thanks, Rima. Important things that that we all need to know and figure out how to deal with going forward. And I'm going to move on to a topic that has no controversy whatsoever. Political expression in the workplace, and really it's both in the workplace, outside of the workplace. It's really political expression by employees, by your employees, do's and don'ts, and how we need to respond. Now, I know some of us thought that we might be over this by now on the date that we're on, but guess again, we're not over it, and political expression and only seems to be increasing. My social media has blown up, and we are fielding questions from clients asking how should they respond? Should they respond to posts and expressions and protests and demonstrations if they arise in or outside the workplace? So I'm going to spend just a few minutes talking about these topics: employee protection laws, the year of protests and political unrest, just to kind of frame the issues for us where we are, responses to those. There have been a number of lawsuits recently, and we're going to talk about those, the main ones, and give you an update on where they are. And then finally, share some best practices to manage those expressions in the workplace. How should we respond to our workforce to create the best possible situation? So I've spent this year, and particularly since many of the demonstrations and protests started this summer, talking to friends, seeing friends post on Facebook or other places, saying they have a right to express themselves. They have a right to demonstrate. They have a right to protest. And the question many are asking, or have at least posted, is certainly I have a right to do that in the workplace, right? My employer can't tell me what I can share and what I can't share. I have, and it's framed this way, I have a First Amendment right to speak my mind and to say what I want. Now, I know that we all have employees who are thinking that, even if they haven't come out and said it out loud yet. And I also assume that we have managers and supervisors who may have that understanding as well, and who may be guiding and leading our employees. So I think it's helpful to have a quick reminder that of the difference in the public and the private employment setting. A quick reminder that in the private employment setting, employees, they don't receive that First Amendment protection. First Amendment protections apply to state action, not private employers. And that action also needs to relate to matters of public concern. In the public setting, certainly that protection is there, and employees generally, they can't be fired and disciplined, face other action based on their political speech or their party affiliation. But that's not true for employees of private employers, at least when it comes to First Amendment protections. However, some states offer employees protection in the workplace, and we're not going to go through every state because a number of states have enacted protections, but here are a few to be aware of. Colorado employers may not threaten to take action against employees, including discharge, because of employees' connection to a particular political party or because an employee engaged in politics. California employers can't adopt rules that prohibit employees from taking part in politics, and they can't threaten to fire an employee for engaging or refusing to engage in a certain political activity. Here's one that I think is particularly broad. Connecticut employers cannot discipline employees, including discharge, for exercising their First Amendment rights. Now, there are some carve-outs, and as long as the activity doesn't interfere with job performance is one of those, but that's a pretty broad restriction. Connecticut employers can't discipline employees for exercising their First Amendment rights. So a number of states have these laws, and a number of states have a much more broader law that says you can't coerce or influence an employee's vote in an election. Violating those laws can lead to wrongful termination claims. Some of those may be spelled out specifically in the statute. Some fall under the common law if the state allows it. But we recommend that you take a look at the laws where you have employees working. Look at those specific states, because each of those states may offer a different protection. Additionally, even though we're past the general election, for those states that have runoff elections on the books and are scheduled, there are laws that allow employees to have time off for voting. Most of those laws include a statement that if the employee can vote before their shift or after their shift, you don't have to give them time off during the day. However, if they can't, you do have to provide those employees time off. Take a look at the state laws where you have employees, because some of them may need to exercise those with runoff elections upcoming.
Matthew,
yeah.
sorry to interrupt, but real quick, you just were talking about some states who did provide protection for employees who engage in political expression. What should employers be thinking about? What should they do with steps to protect themselves?
Yeah, Stuart, that's a great question. First, as we said, it's state by state. Look at what that particular state protects and make sure that you're aware of any actions you take not running afoul of that. But I think, more importantly, particularly in this time of heightened political expression, heightened demonstrations, heightened protests, employers need to really look at before they take discipline, particularly that discipline that we all know is considered an adverse employment action, discharge, pay cuts, those things. And if you're about to take those actions and the employee has engaged in something that could be considered protected, stop and look at the law. Stop and look at the actions that you're taking and make sure that you have grounds for them. And then, as we always say in the HR and the employment context, document, document, document. It's going to be particularly important, particularly in some of these cases. There are going to be cases of, where courts have dealt with this for the very first time. It's going to be important that you make sure you have your personnel files documented in such a way where you can walk in with evidence that support your actions. I think that's going to be particularly important going forward as we test out some of these laws. So outside of the public versus private, there are some protections. What do we need to be concerned about other than those wrongful termination types of lawsuits? And what we're seeing in some of the recent lawsuits we'll get to is that employees have taken their political expression or demonstrations or employers' response to them, and they've turned those into Title VII lawsuits. And just to be clear, and to make sure that we're not mixing public and private too much, remember that numerous courts have held what the Florida court here states is that Title VII does not protect speech or political views. That's important. The plaintiffs in that case, in the Silva case, had complained that a CEO had sent out a letter and a sample ballot with their paycheck. And the CEO had expressed his political opinions on company letterhead. There were 2 employees who were ultimately terminated for misconduct, but they filed a lawsuit and said they believed that they were terminated for their disagreement with the CEO's political views. And I think this is important. What the court said was, even if the real reason for termination was the employee's speech or political views, Title VII does not protect that speech. So what does it protect? Rima covered some of this. We all know those categories of race, color, sex, religion, national origin. We're not going through that list. And you are well versed on those protections. But we do want to point out that the lines do become blurred when employers take action against employees for conduct, sometimes within the work setting, sometimes outside of the work setting. And the question is, was that conduct political speech, merely political speech, or did it cross over into something that would be protected? For example, when is a post on social media that could be viewed as political speech also a violation of a handbook or a code of conduct? Employers do have an interest in guarding their reputation, and we all have social media policies and codes of conduct. And when employees' actions cross the line and become offensive or harassing or inappropriate, employers may still follow, and in fact need to follow, their own policies and discipline those workers. And each of those is a fact-specific case, and you'll have to look at each one of those situations. Well, what about the employee who engages in political expression in the workplace? Is it just an expression, or could it also be deemed to be an internal complaint? And we're seeing much more with that, both in the religious liberties context and in the racial justice context. If an employee is opposing something they consider an unlawful practice, have they done enough to gain protection under Title VII? When are employees merely expressing their political views? And when are they expressing a complaint about their employer or about a condition of their employment? And we're also beginning to see some Section 1981 claims. And as Rima said, we've got that new but-for causation that we've got to look at, but we're waiting to see some Section 1981 retaliation lawsuits filed when an employer disciplines employees for participating in protests concerning racial justice. So in addition to Title VII, which we're going to talk about again when we get to some of the cases that were filed, there are questions about when employees' activities become concerted activity and receive protection under the National Labor Relations Act. So even in our, remember, even in our non-union work settings, when employees come together, they may engage one another in concerted activity, and they may self-organize to address work-related issues. One question that's not as clear as we would like is what is concerted activity and what is separate political speech? And unfortunately, that decision depends largely on the current views of the NLRB, which remember is a political body. It is appointed. And there are a lot of people who think that the pendulum on the NLRB is about to swing back and offer greater protection for employees. We'll have to wait and see, but there are lots of people who are writing about that already. What about, wearing badges and buttons related to unions and unionization? Sure, generally those are allowed. But what if they cross the line into political speech, more so than union-related speech? What if those buttons and badges or t-shirts or everything else look more like a concern over a workplace setting than they do over a political candidate or a political issue? What about signs for a specific political candidate? Bumper stickers. Many of those are going to be dictated by your handbook concerning dress. And if it's not in your handbook, you probably need to revisit that now. What about specific solicitations for political support? Your handbook may also address that and say we don't allow solicitations in the workplace. So with that legal backdrop, both the public and private backdrop, the wrongful termination, Title VII, NLRA, against that backdrop, there have been a number of things that are happening this year. Political unrest, protests, demonstrations that are spilling over into employment issues. So you may remember back in June, Facebook employees staged a virtual walkout. And some of those employees added to their Facebook email an automated response that said they were specifically out of the office as a sign of protest. At Facebook, some staff members, including supervisors, circulated petitions amongst their coworkers as a sign of protest, and they asked the company to take certain actions or take certain positions. The question is that simply a political expression? Is that simply political speech? Or does it rise to the level of being an internal complaint? As soon as it rises to the level of being an internal complaint or potentially an internal complaint, well, employers have to stop. And they have to say, before I take action, is this going to violate Title VII? Is this going to be viewed or at least give rise to a retaliation lawsuit? Later in June, employers faced a nationwide strike for Black Lives, in which employees all across the country, in different industries, walked off the jobs. And employers took different positions, depending on their employees, their setting, their workforce, their rules, their policies. And some of those employees actually faced discipline for abandoning their jobs. And that should make you think about potential Section 1981 claims. In response to actions taken by state and local governments, we've also seen some anti-lockdown protests, and employees are demonstrating and stating that the economy should open up more fully. Now, those protests appear to be less focused on employers, and there seem to be fewer, but with signs that COVID-19 cases are increasing and a change in government action, we can expect those protests to increase. The response to those employee protests, those expressions, and those complaints have led to a number of different lawsuits. So the first one here is the one that Rima and I were talking about earlier, the Kroger lawsuit. Last month, the EOC filed a complaint in the Eastern District of Arkansas against Kroger. It alleges violations of Title VII based on religion. And as we said, the EOC claims that Kroger failed to accommodate employees' religious beliefs and retaliated against them. And the dispute first arose when Kroger changed its dress code. It required employees to wear new aprons with a new logo that was a rainbow heart embroidered on part of the apron. Some employees complained, and they said they had a good faith belief that that logo represented support for and an endorsement of the LGBTQ community. And their complaint was that wearing the logo was contradictory to their well-established religious beliefs. Ultimately, Kroger terminated one of those employees after she refused to wear the apron, or she wore it with her name tag covering up the logo. The EOC filed suit claiming Kroger refused to accommodate her religious beliefs and disciplined and terminated the employee because of those. The EOC also claimed Kroger retaliated against the employee for expressing a complaint about an accommodation. Now, Kroger has not yet answered. The answer is due within a few days, but we all need to be aware that each action we take, whether good intentioned or not, it needs to be reviewed through the lens of whether it potentially creates a cause of action for our employees. And we need to think about each time an employee raises a complaint. Once again, is it political expression? Is it political speech? Or is it an internal complaint that we need to view through that lens and investigate? So you've likely seen the case of Whole Foods and Amazon in the District of Massachusetts.
Matthew, I'm sorry.
Yeah.
Before you jump in, for those of you who need a code for CLE credit, the first code is Bostock, the case that Rima talked about earlier. We'll give the final code a little later. Sorry.
No, thanks, Stuart. We got to get the important things out there. So the Whole Foods case filed in July. Grocery workers were required to wear face coverings, as many of us have been, and Whole Foods workers protesting racial violence and other discrimination began to show support for the Black Lives Matter movement by wearing face coverings that said Black Lives Matter, or BLM. They said they did this to protest racism and police violence and show support for Black employees. Whole Foods began disciplining those employees for wearing face coverings and those specific face coverings. The complaint alleges that Whole Foods had not previously enforced its dress code policy and that it had not disciplined other employees who were wearing face messages or shirts or other things, including political messages. But yet, when these employees began wearing Black Lives Matter face coverings, the company began sending them home without pay. The complaint also states that Whole Foods threatened termination if employees continued to wear their masks. And one employee who claimed to be a lead organizer actually stated she was terminated because she wore the mask and because she had organized others to do so. The plaintiffs allege that Whole Foods and Amazon violated Title VII by discriminating against Black employees and others for showing support for Black employees in the movement. In support, they talk about the selective enforcement of the dress code. Whole Foods and Amazon have moved to dismiss and claim that plaintiffs have failed to state a claim under Title VII. And their argument, as you would expect, is that all employees were treated the same and that the plaintiffs had not even alleged that the dress code was applied differently based on race. So that's all briefed up before the court right now, and we're waiting to see what happens. And although based on the briefs alone, it appears Whole Foods and Amazon may have the better argument. We're watching to see what happens, because if that lawsuit is allowed to go forward, if it's not dismissed, we expect similar lawsuits to be filed in the future. The last case I'm just going to briefly mention, I started with a public versus private, so I thought I'd give you a public employer lawsuit, Allegheny County. In that case, the union brought a lawsuit against the Port Authority claiming that the employees' 1983 rights were violated when they were not allowed to engage in political expression or political speech. And specifically, once again, they were trying to wear face coverings that said Black Lives Matters. And they claimed that the Port Authority had changed the dress code specifically to deny them that opportunity. The union claimed that the Port Authority had previously allowed people to wear shirts and face coverings and different things that had endorsed different messages: Pride Month, African American Heritage Day, women's rights, the American flag, but that the company, the Port Authority, changed the policy when they began to wear Black Lives Matter face coverings. The Port Authority changed its policy, moved to dismiss, and the court recently dismissed the case, but allowed the union to refile an amended complaint, which it just did last week. So in the midst of all of these activities, all of this turmoil, all of this political unrest, we do think there are a few items that you need to be concerned about and you need to put into best practices. Three main areas: handbooks, Rima already talked about that briefly, internal response plans, and training. Handbooks and policy changes. If you haven't done so lately, you need to review your policy. Specifically, take a look at your social media policy, your code of conduct, your workplace violence, and your attendance policies. And you need to make sure that they're being enforced consistently across the board. We also recommend that you have an internal response plan. And it covers more than just demonstrations and protests at work. But what we think is important to have a plan in place so that in the event something happens, you're ready to respond appropriately and you're not flying by the seat of your pants. That response plan can include, contact personnel, who can speak on behalf of the company, who do we need to reach out to? And finally, you need to conduct training with managers and supervisors. As I said, some of our employees don't even know what protections they have and what's available to them. And our managers and supervisors need to be clear to those different so that they can offer the most help in the workplace. That training also needs to include de-escalation techniques because we're seeing more and more confrontations in the workplace by people who are on different sides of the political fence. And we've got to find a way to reduce that heat. And that kind of leads right into what Stuart's going to talk about, which is all of those steps are all about managing our workforce during this difficult time. And Stuart's going to talk a little bit about managing your workforce during a pandemic.
Yeah, thank you, Matthew. And we're running a little short on time. So in the interest of time, I'm probably going to run through this pretty quickly. I apologize in advance if I sound like a county auctioneer, but I'll try to get to most of my points. We're now 8 months into this grand experiment of managing a workforce through COVID. So I'm going to talk about some things that many of you have probably already likely have encountered, but it probably serves as a good opportunity to remind everyone of some of the guide rails that govern employers as we go through this. I'm going to start off by talking about privacy issues, and those mostly concern privacy issues relating to COVID testing and diagnosis. And as most of you know, the Americans with Disabilities Act, which has now been in effect almost 30 years, has curtailed the number and opportunities for employers to test, provide, ask medical questions or test employees. In the context of COVID, the EEOC has been very clear that some of these rules have been relaxed. Generally speaking, you're required to do testing or ask questions. You're supposed to show that testing or those questions are job related and consistent with business necessity. And what the EEOC essentially has said is that in COVID, that doing tests for COVID and asking questions related to COVID symptoms, et cetera, is job consistent with business, job related and consistent with business necessity, mostly because COVID does and can create a direct threat to employees' health and safety. So one of the things they've said employers can do is you can test your employees for COVID. I think the first thing you need to ask as an employer is, should I test our employees? And I think that requires an examination of your workplace or workplaces. Do you have employees who work in close proximity on an assembly line together? In that circumstance, you might be more likely to want to test those employees. Do you have employees who are in individual offices, like you might see in a law firm, for example? Your need to test might be a little bit diminished. On balance, if you decide that it makes sense to test your employees, then you need to think about, when do I test my employees? If we're bringing everyone back in from a period of remote work, do we test them immediately? Do we test everyone? Do we decide, who we need to test based on where they work? Do you test on a regular basis, or do you just test initially? Do you test when people show symptoms? Those are the sort of things you need to think about. And I know there's not a lot of travel right now, but if you have employees returning from travel, do you test them when they return? Do you test them immediately? Do you wait a few days to make sure that if they have COVID, that it's something that shows up in a test? So if you do decide to test, you do need to have a written protocol that talks about all these things. And among those things, you need to figure out what kind of testing you need to do. There are different kinds of viral testing now. The state of the art keeps changing there, so pay attention to which tests are most effective and suit you the best. You can take employee temperatures. You can have someone with one of those guns as employees walk in. You can take their temperatures, send home people who present with fever. If you do take a log or keep records relating to that, you definitely need to make sure those are kept separate from their personnel files, because those are medical records, even though it sounds fairly innocuous. You can, and this is relatively common sense, but you can ask employees if they have experienced COVID-related symptoms. I've listed a few of them on there, more typical ones you see: fever, chills, cough, shortness of breath, loss of taste and smell. There are others: muscle soreness, nausea, fatigue, body aches, that sort of thing. The CDC kind of has a running list that you want to be aware of. I would limit your inquiries to those approved or those recognized symptoms when talking to your employees. You can ask, I think you might want to require employees to present or to report if they're presenting those symptoms. If you have an employee who has been infected, or a visitor who's been in the premises, it makes sense to and you really should inform your employees of that positive test. You should not give the name of the person unless you've been given permission by that employee, which we'll talk about in a moment. But you should provide the employees with enough information to determine whether or not they had a risk of exposure. Certainly informing them where that person worked, the area of the facility, that sort of thing is what you'd want to share, so that employees can gauge: is this something I need to be worried about? Is this something where I could have been exposed? Again, you should have a policy requiring, if employees do test positive, that they inform the employer. That again is fairly common sense. So go to the next slide. Those issues were primarily related to the workplace as a whole. If you're dealing specifically with an employee with a positive diagnosis or positive test, there are a few ground rules I think that are worth covering. If you have an opportunity, try to talk to that employee after you become aware of the positive test. Try to get as much information from that employee about, where the person works, but if you can find out with whom has that person been near, have they spent a lot of time outside of their work area with specific employees, get that person to identify those employees. Has that person been to other places in the facility? If you have a cafeteria, has the person eaten lunch there? Who was with him or her? You need to ask those questions just so you can help protect the rest of the workforce. You can ask for permission to give the name of the employee to the workforce at large. You're going to have to tell their supervisors and the need-to-know types of management employees about the diagnosis. But if an employee gives you permission to tell or give their name, you can do that. Ideally, you could get that in writing. I think that's the safest, but certainly circumstances might prevent that. If the employee is away and has no means to communicate by email or something like that. So again, as I mentioned with the testing of the temperature testing, keep any information relating to a positive diagnosis separate from personnel files. And finally, for that employee who's been out, you can require fitness for duty examination and certification from a doctor to return to work. What you want to do is make sure you've communicated that to your workforce in advance, so they know that that's something that's going to be required, and make sure you're applying it consistently. If you're using it, if you're requiring it in one case, make sure you require it across the board. Okay. managing a remote workforce, many of you are probably dealing with a remote workforce for the first time. Some of you probably have had employees working remotely for a while. The same rules for those of you who have experienced this, the same kind of guardrails should apply in this circumstance as well. It's very important to communicate with your remote workforce. They need to know, first of all, that, for example, company rules apply. There shouldn't be any 12 o'clock happy hours. You shouldn't be sending lewd messages to coworkers via text. Just because you're at your house doesn't mean that the rules that govern the employment relationship don't apply to them. They must do their work. And I know that sounds pretty obvious, but you need to make sure that's communicated to employees as well. If they work, especially if they're hourly employees, they need to let you know the hours that they worked. We'll talk about that in a little bit on the wage and hours.
Stuart, can I interrupt you for a second?
Sure.
That's come up for some of my clients is how to apply workers' comp and OSHA type rules when they're working from home. What is the application? I mean, does that still apply?
Yeah, no, that's a great question, and it's actually dealt with by in the OSHA regs because this has come up with the proliferation of working from home. Generally, it comes down to whether or not the injury was caused by the employment or occurred during the employment. And there are examples given by by OSHA and the regs. For example, if you're carrying a box of documents for work and you drop that on your foot, that's fairly clearly related to your employment. If you get a phone call and you have to go across the room to grab the phone and it's a work phone call and you trip over the phone cord and get hurt yourself, that's work related. That's something that would be covered under workers' comp and also, depending on severity, potentially reportable under OSHA. If you hear your baby crying in the next room and you get up and run and trip, that's not work related. Responding to your child has nothing to do with your job. But that's a great question. I'm sure that has come up.
Are employers evaluating people's homes as workplaces, or are you just kind of at the mercy of how safe their homes are?
Well, I mean, I think the easiest thing to do as employer is if you have a written policy, remote work policy, is place that obligation on the employee to provide themselves with a safe workplace. It's very difficult for an employer with hundreds or thousands of people working remotely to inspect all of their work sites to make sure they're safe. So to the extent you can, put that on your employees. If there are under the general duty clause, if there are hazards that just attach to that employment in general, you might have a heightened obligation, but for the most part, just tell them to work in a safe work environment. We've gotten to the end of the hour. I've got more things to cover. Perhaps the best way to deal with this is if you have questions. I think we're going to provide, I don't know if we're going to provide the slides to everyone, but maybe I'll just go through it real quick, even though we're a little past time. If you go to the next slide.
Yeah, Stuart, and before you do, I'm going to go ahead and give out the code, and if folks need to jump off, that's fine. We are going to provide a copy of the slides to everyone. You'll also be able to access the presentation on our website. So if you do need to jump off and you want to finish the end, you can. The second code is update. And so just a reminder that the first code was Bostock, and the second code is update. And Stuart, we'll let you kind of finish up on your presentation. Thanks.
Sure, and I'll go through this quickly. Those of you who've already had remote workers have thought about these things already. But if you have, after COVID's over, hopefully soon, we have a vaccine and everyone can return to work, you're gonna have employees who've been working the facility before who now wanna work from home because they got used to it. You need to think of, in some circumstances that might be a reasonable request and some it might not be. But you need to think about things, balance the same considerations you would in a normal circumstance. Look at the type of work they perform. Is it something that can be performed as effectively remotely versus at your facility or in your office? That certainly weighs in. Is it a job that requires collaboration between employees? Person-to-person collaboration or meetings can sometimes be more effective than Zoom calls. So that's something you need to think about. You obviously need to look back and see during COVID, how effective was the workforce? If the workforce was less productive, that might be something that would suggest that perhaps you need people to come back into the office. So we'll go on to the next slide real quick. I want to touch on a few wage and hour issues. If you have exempt workers, and most of you do, most of you sitting on the phone call are probably exempt. you need to make sure you protect those exemptions. If your economic situation requires you to maybe make pay cuts, you can do that for exempt salaried employees as long as they're paid at least the minimum salary, which is now $684. And you can show that there's a bona fide reason for doing that. You're not doing it just to save money. You also can't do it retroactively. You can't go back and cut pay for time already worked. Again, you can, if you go to a 4-day work a week, you can require on the 5th day the salaried employees use vacation time or paid time off if it's under a benefits plan or on a bona fide pre-existing benefits plan. You can have supervisors on a very interim basis perform hourly work. You can have a supervisor operating a forklift, for example. Again, I wouldn't do that on the long term. You know, that's more of an emergency situation. That won't affect their status if it is temporary. If you have a collective bargaining agreement, though, make sure you're not doing anything by signing that work to employees. Make sure you're not violating your bargaining agreement. And finally, on the last slide, for non-exempt workers, if they perform work, you have to pay them for it, even if you didn't authorize it. If you know that they or have reason to think that they performed work and they didn't report it, you still have an obligation to pay. You need to follow up with them to make sure they report their hours. If their work from home requires them to spend money or to use their personal equipment to do their work, look at that, see if that affects whether or not they're receiving minimum wage once you would deduct what that cost was from what they're being paid. Most people probably won't have that as an issue, but that's something to think about. Volunteer workers, same rules apply. Are they working for their benefit, or are they working for yours? The COVID hasn't affected that analysis. And another thing to think about, and we really don't know the answer yet, is if people are queued up to be tested for COVID or have their temperatures checked before work, is that compensable time? Is that preliminary, post-preliminary activities? That'll all shake out in the courts coming up. So you already have the second code. I think we've gone a little bit over, so I'm going to let everyone go. Thank you again for your time. Hopefully this was helpful to you. If you have any questions, feel free to reach out to any of us. You have our contact information in the slides as well. And this was fun. Thank you.
Thank you.
Thank you.